So, Jake, Mig Killer, Migaroni, Megatron, Megaman, Meganator, Megamental Rights. Let's talk about Proposition 8. Now, anyone familiar with my channel knows that I don't do politics, at least not on YouTube. But Jake, you did kind of address your video to me, so I feel obligated. And now, luckily, you did a lot of the work for me. I mean, I know you're a politics guy, you love constitutional law, so you spent a great deal of time outlining the fundamentals of this entire issue, what the Constitution says, what it doesn't, what states can do, what they can't, and so on. In fact, you spent so much time on exposition, you seem to forget to make an actual argument. But first, let's go over that on which we agree. You said the United States government may not do anything unless the action under consideration is somehow authorized by the Constitution of the United States. You said states can do anything they want to so long as it's not explicitly prohibited by the Constitution of the United States. You read the first section of the 14th Amendment, specifically that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. You explain that this means no state can unequally apply the law toward one group of people and not another, and that the laws must apply to everyone equally in any state, and that the plaintiffs in this case argued that the state of California was applying marriage laws unequally by not granting the same marriage eligibility to homosexual couples that they granted to heterosexual couples. You said that unless a law overtly targets a certain group or is applied unfairly to one group, we have to examine the law on the basis that there is some state interest or rational basis. And then you said this, quote, well, is there a rational basis for the California law? Of course there is, and that is preserving the traditional model of marriages between one man and one woman, end quote. You went on to say, quote, the question under deliberation over Prop 8, however, is whether or not anyone can marry anyone else of his, her, or their choosing, end quote. You explained that among other cases, Judge Walker cited Loving v. Virginia as a reason to strike down a law prohibiting same-sex marriage. Now, for those of you who don't know, Loving v. Virginia was the case that overturned the Racial Integrity Act of 1924, the one that defined marriage in such a way that whites could not marry non-whites. Now, Jake, you said this, quote, the problem, however, is that Loving v. Virginia, this is a mistake actually, you mean the Racial Integrity Act here, was struck down in Loving v. Virginia on the basis that it did not withstand rational basis scrutiny. Though the law prima facie did apply to all persons equally, the motivation for the law had nothing to do with any compelling state interest. Rather, the law was created in order to preserve the supremacy of the white race, end quote. Actually, it's not quite that simple. The Racial Integrity Act wasn't passed to preserve the supremacy of the white race, although any rational person could infer that in the same way that any rational person could infer the supremacy of straight couples from Prop 8, but I digress. Rather, the Racial Integrity Act was passed to preserve the, for lack of a better word, consistency of both white and non-white races. Eugenics was a hot topic back then, and they argued that it made for a compelling state interest in keeping bloodlines consistent. Now, Jake, I could not agree with you more that something like this is utter bullshit, because even if the science of eugenics didn't turn out to be hogwash, this law needed to be overturned because there is no state interest in defining marriage as between two people of the same race, no matter the ideological motivation. However, your argument was that the motivation for the Racial Integrity Act had nothing to do with any compelling state interest, while Prop 8 does, and this is why Walker citing Loving v. Virginia was inapplicable. But that's funny. Why would there be a state interest in defining marriages between one man and one woman? You kind of forgot to explain that part. See, your private religious ideologies provide no more of a compelling state interest in the definition of marriage than the private racial ideologies of the guys behind the Racial Integrity Act. So who are you trying to fool, Jake? Prop 8 was struck down on the same exact basis as the Racial Integrity Act. It does not withstand rational basis scrutiny. Now, would you like to provide an intelligent argument that it does? Because the defense for Prop 8 tried that, and it was fucking laughable. Prop 8 protects children. Prop 8 provides stability in relationships. Prop 8 recognizes that the ideal child-rearing environment requires a father and a mother. This is not me paraphrasing. These are actual arguments put forth by the defense, and all of the expert witnesses demonstrated that each and every one of them were false. Not that you need an expert witness to tell you that each one of these is absurd. When the defense argued, quote, responsible procreation is really at the heart of society's interest in regulating marriage, end quote, they were naturally asked for evidence of this, to which they replied, quote, you don't have to have evidence of this point, end quote. Even when they were granted the assumption that the state's interest in marriage is procreative, the defense was asked how same-sex marriage impairs or adversely affects this interest. The defense's reply, you're going to love it, quote, Your Honor, my answer is, I don't know. I don't know, end quote. Now, you may wish Judge Walker had ruled differently, but with such brilliant argumentation on the part of the defense, can any rational human being seriously blame him? Seriously? There's a reason California State declined to defend Prop 8, leaving it in the hands of private advocates instead. They knew they didn't have a case. Even the Attorney General conceded that Prop 8 was unconstitutional from the beginning. Preserving traditional marriage as between a man and a woman is not a state interest, Jake. That's a private interest. And in fact, it's a private interest that is deleterious to the state interest of equal protection. So frankly, I don't know where the fuck you're coming from. You also said, quote, recall my dissection of the 10th Amendment where I showed that states can do whatever they wish as long as it's not prohibited by the Constitution. So yes, Scott, you do have to prove that the abridged right is an enumerated fundamental right before challenging a state law, end quote. No, I don't. But I'd be happy to, and I will. My point, though, wasn't that marriage is a fundamental right, although as far as this case is concerned, it is, as stipulated by both the defense and the plaintiff. My point was, whether marriage is a fundamental right and for whom it's a fundamental right cannot be decided by way of popular vote in an election since, quote, fundamental rights may not be submitted to a vote, they depend on the outcome of no elections, end quote. What this means is Section 7.5 of the California Constitution's Declaration of Rights, the one established by Prop 8, was enacted illegally. Now, you'd be dead wrong, but you may try to argue, as the defense did, that Prop 8 is still constitutional since it does not violate the Equal Protection Clause because all it did was redefine marriage as between one man and one woman, and that this definition applies to everyone equally. You may say gay men are afforded the right to marry. They're afforded the right to marry women, just like straight men. See? Equal protection. Oh. Now, I shouldn't have to explain how stupid that is, but I'm going to anyway. Under Prop 8, straight men and women are afforded the right to marry the consenting person of their choice, but gay men and women are not afforded that same right. Get it, Jake? Because you're straight, you have the right to marry anyone you want, but if you were gay, you wouldn't have that right anymore. So, homosexuals are being discriminated against according to their sexual orientation. But that's only half the story. Proposition 8 violates the Equal Protection Clause not just because it discriminates on the basis of sexual orientation, but on the basis of gender as well. I'll give you an example. My friend Michael is gay. Under Prop 8, Michael is prohibited from marrying the person of his choosing, his partner Steve. This is only because Michael is a man, and I'll prove it. If Michael were female, then Michael would have the right to marry Steve. Michael's neighbor Sally can marry Steve, but Michael is not afforded that right solely because of his gender. As such, Prop 8 prevents Michael from enjoying equal protection under the laws by the 14th Amendment of the Constitution as, quote, freedom of personal choice in matters of marriage and family life is one of the liberties protected by the Due Process Clause of the 14th Amendment, Loving v. Virginia. And, quote, freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men, end quote. Griswold v. Connecticut. You may try to argue, as the defense did, that plaintiffs are seeking a new and different right than that of heterosexuals, the right to same-sex marriage. But to do this, you have to demonstrate a qualitative difference between the obligations, duties, and privileges for members of a same-sex marriage and the obligations, duties, and privileges for members of an opposite-sex marriage. Search all you like, you will find no such difference. As far as the law is concerned, there is no man role or woman role inherent in marriage. Now, this may not always have been the case historically, but it's undeniably the case now. Even in any heterosexual marriage, there is no duty, obligation, or privilege assigned to one gender and not the other. In other words, the conjugal role of a man and the conjugal role of a woman are indistinguishable. It's the same role. Further, there is no obligation in marriage that could be fulfilled by members of opposite sexes, but not by two members of the same sex, especially since procreation has never been a marital requirement. This is what Judge Walker meant when he said this in his ruling, quote, "The right to marry has been historically and remains the right to choose a spouse and with mutual consent join together and form a household. Race and gender restrictions shaped marriage during eras of race and gender inequality, but such restrictions were never part of the historical core of the institution of marriage. Today, gender is not relevant to the state in determining spouses' obligations to each other and to their dependents." End quote. Your response to this was to say the following, which, by the way, demonstrates to me at least that the relevance of the point escaped you. But you say, quote, "I must repeat that the founders and framers of the 14th Amendment were establishing a standard. If a law was constitutional in 1900, and if there haven't been any changes in the Constitution relating to that law, the law is still constitutional." End quote. Yeah, and if a law seeks to withhold from someone their right to marry based on sexual orientation, gender, or race, it was unconstitutional in 1900, and it's still unconstitutional. That it's taken us this long to realize that is tragic, but irrelevant. There is no difference between the right to gay marriage and the right to straight marriage. They are indistinguishable. There is only the right to marriage. And under Prop 8, straights have it, gays don't. And thus, Prop 8 violates both due process and equal protection under the 14th Amendment and is thus unequivocally, Jake, unfucking equivocally unconstitutional. In addition to being an offensive, hurtful, morally appalling, and idiotic display of primitive religious bigotry.